I have a couple of things that came to mind when I was reading the ordinance in regards to the District Management Corporation. I was wondering if it's possible to eventually see the bylaws or the certificate of incorporation or the incorporation papers, since it's not established through the ordinance. Is that correct? Is the corporation established through the ordinance, or is it separately incorporated?
It's a Title 15A nonprofit corporation which seeks tax-exempt status from the IRS.
But it will be established in a separate incorporation proceedings, correct?
It may not be. As you heard, there's a discussion that perhaps they can convert the Main Street South Orange Corporation.
Okay. There's a section 3A4, the company can enter into all agreements and contracts that it deems necessary or convenient. And there's no time limit, so for all intents and purposes, this company can go into a 10-year contract that extends over the time that the SID might be disbanded or might be decided not to renew it, and we're stuck with the contract. So that concerns me a little bit, that the company can immediately enter in such long-term contracts. The DMC is also allowed to fund improvements through loans. So I'd like to know what the collateral is. Is the collateral going to be the businesses that it's actually improving, or is it the pool of businesses, or is there any village credit involved? But there has to be some collateral for any loans that this company is taking. So that's a concern I have. And I'm actually mostly concerned that this DMC is allowed to hold property to buy and sell. That, for me, is not only a concern for me as a resident, because as per the termination clause, we are to acquire not only the assets, and we're not, it's stating acquire and not take over. So acquiring to me means you have to pay for it to a certain degree. So if we're acquiring the assets and take on any liabilities, if this DMC has purchased several buildings, we're stuck with them. The other question, the other issue I have with that, and I'm not a business owner, is that with the mandatory participation of the businesses, you're exposing them directly to a real estate risk that they might not feel like taking. These businesses might not want to be exposed to any additional real estate risk, which they are if their entity, the DMC, now holds property. So that's, I think, a valid concern of business owners, that they might not, in this environment, be exposed to any more real estate risk. There's a section 3A10, which states that the DMC is going to enforce conditions of any loan made by the corporation. That would be nice to be clarified what is meant by enforcing, and enforcing against whom. Is it enforcing it against the individual, depending on who's going to be responsible for repayment of any loan if there's a default, or is it going to enforce it against the pool of the SID itself? I'm a little disturbed that this not-for-profit seems to be going into seems to expose itself to medium to high-risk transactions, meaning real estate mostly, since that's not really the nature of a not-for-profit. And the impression that was given was that this entity was here to simply provide services. It was never, I never understood that it was supposed to actually hold assets and transact in ownerships. So that's a little concerning to me. And the fact that the DMC is created as a not-for-profit does not shield us as the village from any liabilities. As a matter of fact, there is a case law, Hogan versus the Township of Haddon, where the situation was simply that after the first initial time frame passed and the SID was extended, the township was no longer happy with the board, and the township wanted to step in and remove the board of said DMC, and was no longer able to. And they went to court, and they have been made very clear that once it is renewed, the township has no rights in any way, shape, or form to make any suggestions to change the board or how the board is elected. So that's a concern, because in reality, once you renew, you can't stop, if you want to be dramatic, a rogue board. You can't. So that bothers me, because again, with the termination of the company, we're again stuck with all the assets and all the liabilities. And the assets, as nice as it sounds, but they can be a liability if it's the wrong market. So it would be really, I think, for all residents, and I'm not talking a business owner now, as a resident, because I was never aware that we are going to hold the bag in the end if something goes wrong. I think it would be really appreciated if this could really, really be worked through, because I am not comfortable with your control just by budget. I want to see either a lot less powers in such a from such a corporation, or a lot more influence that we can step in, because right now there's nothing. And I'd be happy to leave you guys the case law, but that was very clearly stipulated, and it's not the first time that this happened either. So I really would hope that this is really thought through, because I do not want to be stuck with this company and then we have no recourse whatsoever if it doesn't go well. And unfortunately, our real estate dealings have a lot of times not gone well. Thank you.
Thank you.